Good morning. Welcome to Legal Access, brought to you by the McGuire Law Firm. Today's topic, in case you're interested in getting on the air and asking about it, is criminal law. That envelops a lot of things, including traffic tickets, drug arrests, DUIs, anything else, court system, sentencing, plea bargains, bail, bond, any kind of questions you might have about the criminal justice system. Today's the day to get those questions answered, whether it's something specific or in general. That's great. Give us a call. The number is on your screen. On the panel today to answer the questions on criminal law, first of all, to my left is Billy Monkton. Hi, Billy. Welcome back.
Dave, good to see you.
What is your firm, and besides criminal defense, what else do you do?
My firm is Monkton, Henry & Humphreys. My law partners are Fran Humphreys and Senator Greg Henry, and we primarily do criminal defense and personal injury.
All right. In the middle, we have Seth Oskin from the solicitor's office, and you deal with everything, obviously.
Yes, sir. Senior prosecutor, run a team anywhere from shopliftings to murder, and got some specialized teams in the office as well that handle everything, like you said.
And to your left, we have Trent Chambers. And Trent, besides criminal defense, what does your office handle?
A little bit of personal injury as well, auto accidents, but mostly criminal defense.
Fantastic.
Yeah.
All right, well, thanks, guys, for being here today. And again, our phone lines are open, 843-848-8080, in case you have any questions about criminal law here today. Now, we were talking a little bit off the air that, obviously, I know that we have, and maybe, Seth, you've got the actual numbers. I mean, how many cases do we have that need to go to court on a yearly basis?
So, as you know, we have about 10,000 arrests a year, so as that builds up over the years, but speaking with Trent, we only have about 24 options a year, our 2 trial court weeks a month.
Right.
And you're going to see realistically about 18 to 22 of those weeks actually hit. So that's a very small number. I'd say less than 2% of cases actually end up going all the way to trial.
So out of 10,000 cases, 24 weeks to be able to try them. So that means that there's going to be a lot of plea bargaining done. So Billy, Trent, I mean, do you use that to your advantage if you've got somebody who is facing charges and you don't want to go to court or you want to plea them down, knowing that Seth only has 24 chances in an entire year to take a case to court?
Yeah, I think that works both ways, really. We can use it to our advantage, but then if they really, want to press it and take your person to trial, they're going to do that. And it may take a little while for that to happen, but it just depends on the client and what they want to do. It's really not our choice, it's the client's choice.
Yeah, I agree with Trent. We get clients from all different levels of crimes and seriousness, and Trent said it best, a client, as we say in our office, a client drives the ship.
Right.
It's their decision on whether they want a plea bargain, their decision on whether they want to go to trial. We discuss with them the options. If we try and resolve it by a plea, here's what you're looking at. If you go to trial, here's what you're looking at. Because, if you go to trial and you lose, you are going to be sentenced to the higher range of whatever the offense may be. It's just the nature of the beast.
Right.
They say they don't punish you for going to trial and losing, but I think the other side is they reward you if you plead. You get what you get if you go to trial, and it's never a good ending if you get convicted at trial.
I don't think either side is too surprised that defendant went to trial. There's, it's on us to prioritize those cases, know what a case is worth. If I've got 3 shopliftings on video that the guy's done it once or twice, 3 times before, or I've got a child hurt or somebody murdered, I've got to prioritize that family.
And speaking of families and plea bargains, I'll watch a lot of crime shows and they'll see somebody who's arrested on this charge up here and then they plead to this lesser charge, and it seems like, they get a very short sentence. Before you offer a plea bargain, do you talk to the victim or the victim's family to see whether or not they're okay with the lesser charges and the lower amount of
Yes, absolutely, and the Victim Bill of Rights requires us to do that. My office is lucky to have a full staff of victim advocates that communicate with people and talk to them throughout the process. You'd be amazed at the people that have awful stuff happen to them, and they seemingly don't care or they don't communicate. And on the bright side of it, they trust you to handle it, and they trust the decisions you make. So that's always a neat interaction there. But yeah, we're supposed to check in with them and make sure that we do.
And one of the other ways to keep people out of the court is with diversion programs, such as youthful offender and things like that, or drug courts. How do you determine who is eligible for the diversion program rather than having them charged with something and going through with the case?
Yeah, great question. My caseload looks kind of like a bell curve, right? I've got very few dismissals. I got very few big sentences at trial yearly, but I got a lot of stuff in the middle. I love pretrial intervention, diversion programs for first-time offenders. I think that's a great opportunity. Hopefully that person just had a bad night. You know, there's other options, conditional discharge, youthful offender, like you mentioned, on their age that lets them clean up their record. And then our treatment courts are a great option as well for people that might have some more serious drug or mental health problems.
I would say probably in the last 5 or 6 years, the treatment court aspect has probably been the best way to resolve a case. If you've got somebody involved with drugs, and I would say 80% of our cases have some kind of addiction issue going on. And there are 3 levels of treatment court now run by the solicitor's office. There's level 1, which is a 90-day program, level 2, 90 days, and level 3 is 18 months. And during that time period, you're drug tested a lot of times twice a week. You have counseling, and if you can resolve the drug issue, you can resolve probably better than 50 to 6% of the crimes we have in our community.
Right.
And the treatment court, if they make it through and graduate, the recidivism is almost non-existent.
That's great.
It's a very tough program too.
Yeah.
I mean, it's if you don't show up or you're late, you're going to jail for a couple days.
Yeah.
If you test positive for drugs, you're going to jail for 2 weeks. If you do that several times, you get kicked out of the program, and you've already pled guilty, and you have a sentence hanging over your head, so you're going to jail if you get kicked out.
You really have to make sure someone's motivated, from my perspective,
Right.
or I'm setting them up to fail. You got to make sure they really want to do it. They have the family support around them to do it, and we've got some really good outcomes from some really bad addicts who've completely changed their lives by going through the program.
Now, since I got people here with the defense and with the prosecution, what's easier, getting one person to hang the jury by thinking they're not guilty, or getting 12 people to agree with a guilty charge?
It depends on the case. I mean,
Absolutely.
it really does. You know, as lawyers, we have very limited ways to pick a jury in South Carolina. We're not really allowed to ask them questions like you see in these other states. So it's pretty much potluck what you get. But as you're in the case, you can really tell by body language by some of the people on the jury. But I've been surprised by that too. Some people who I thought weren't listening to a thing I was saying for 3 or 4 days, I find out after a verdict that they were my biggest cheerleader. So you got to be real careful trying to pigeonhole somebody. Oh, they're for me because this is their job, or they're against me because this is my
Right.
job. Because you really have no idea.
That's right. Yeah, the longer I've done this, I agree with Billy. You think you know, or this person's your biggest fan, they're not, and vice versa. Some prosecutors just pick the first 12 that show up, and I think it can be overthought as well. I mean, if they're there and haven't got out of jury duty, that's about as much as we know, and we got to roll with it based off our facts.
Billy, you and I have been doing this a long time, and I think about 5 years in is when I stopped trying to guess what a jury was going to do.
Yeah.
So.
Tell you what, we're going to run to a break here real quick. When we get back, we would love to talk to you. Our phone lines are still open even during the break. If you'd like to give us a call at 843-848-8080, we'll get you on the air. Criminal law, that's our topic here today on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access as we're talking about criminal law here today. On the panel to answer your questions about all things to do with our criminal justice system is Billy Monkton, defense attorney, and also from the solicitor's office we have Seth Oskin, and also criminal defense Trent Chambers. So we're very well equipped to answer any question you have about traffic tickets, drug offenses, DUIs, any other kind of offense or arrest, plus the court system in general. If you have any kind of questions, please give us a call. We'd be happy to give you their opinions, not mine. I'm just sitting here. I'm not eye candy by any stretch of the imagination. I just ask the questions. That's why I'm here. All right, one of the eyes of the country are going to be back on South Carolina here within the next couple of months as the Alec Murdaugh case will be retried. He's got a new trial that's going to be coming up. Now, as far as attorneys are concerned, if you've had a hung jury and the solicitor's office decides to retry that case, What do you do different, or do you like go back and look at the tape or read the transcripts of what you did and say, okay, I screwed up this, I need to do it differently next time? Or what do you do different when you have to retry a case?
Well, the first thing you got to do is get the transcript, because all the witnesses are under oath, locked in, and if they change the story, you've got it
Right.
under oath. Also, you need to self-analyze what you did wrong in the trial, and I'm sure the lawyers for Mr. Murdaugh will be doing that. There's some things that they probably wish they hadn't have done that they did do, but retrying a case for a lawyer is probably the worst thing to do. It's like watching a movie again when you already know what everything's going to happen. It's just hard. It's hard to get prepped and geared back up to do the same case again, especially when it was that long.
Right.
There were a lot of witnesses, a lot of legal issues that all have to be done exactly again the same way.
And I think that from both sides' perspective, you can expect the other side to be better than they were before.
Yeah. It should be shorter, to
Right.
be honest with you. There'll be a lot of stuff I'm sure both sides realize, hey, we probably don't need to do that again, or put that witness up. So it'll be interesting to see how they do that. I anticipate Alec Murdaugh, he's going to have to testify
Right.
again. I anticipate that, which makes it a little more difficult now because he has pled guilty to all the financial crimes.
Right.
Which makes it easier from the prosecution's perspective.
Yeah, because they don't have
to prove that.
They don't have to prove that again. It is just a hard thing for a lawyer to do, but it should be a quicker trial.
Right.
Based on the evidence I saw when it went through the first time, I wouldn't anticipate a different outcome, quite frankly. I think the most damning piece of evidence in that entire trial was what was discovered 8 to 9 months after the incident was the phone Snapchat video, which shows that
Right.
Mr. Murdaugh was there minutes before everything happened, when he was adamant with everybody that I was not there, and that
And I think that's what they're trying to get thrown out, the kennel video. I think that's what they're trying to exclude right now, the main thing.
I don't think that'll get thrown out.
They got to try, for sure. On our side, and if it's not that intimate of a case or national attention, I mean, our biggest concern is re-victimizing the victims or the victim's
Right.
family. So you got to have some real honest conversations with them. It might be a murder case where a manslaughter plea was close to being accepted, but the deadline's passed and you had to try it. So you just really need to figure out what that case is worth. Is it worth it to the victims? Is it worth it for everyone else to do it and go through it again? It's uncommon, but it's a pain for sure.
Unlike the Murdaugh case, what we'll do as lawyers sometime is trying to find out if it's a hung jury, what was the actual count?
Right.
Was it 11-1 guilty or was it 11-1 not guilty? That can dramatically
Absolutely.
change and make you decide from a prosecution standpoint, do I really want to do this again?
Just more information to give your victims, or as well, saying, hey, there's what we think, there's what we know, and there's what we can prove, right? That's what we're held to the highest burden that our system demands, for good reason. But
And from the defense perspective, if I find out it was 11-1 guilty, I'm having a very hard conversation with my client. Hey, we need to go talk to Mr. Oskin and work out something rather than go to trial, because if that one person had been the other way, you're convicted and looking at substantially more time than you would have.
Well, getting 12 people to agree on anything, any kind of unanimous decision is pretty tough. You can show a school bus to somebody and say, is that orange or yellow? You're not going to get 12 people to agree on what color a school bus actually is. So, I mean, getting 12 people to agree on guilt or innocence seems like it's almost impossible. But, I mean, retrials, that seems to me like that might be an instance where you think in advance. We talked about jury watching to find out, during this part of my defense, everybody was kind of like nodding along and smiling at me. Okay, I need to do that more. I need to really focus on that part of the defense rather than something else, or prosecution, depends upon what side you're on.
yeah, I think so. Let's say we showed some video surveillance and they came back with questions. Where was this at? And perhaps I had that video, but I didn't think it was important because I had tunnel vision in presenting my case, because I've worked this with my co-counsel for 8 months, and it's all, sure, he's got to be guilty, right? But people that aren't in it 24/7, their attention is grabbed by other things. So I think it can help us in that regard. Or some testimony wasn't that helpful. I might not put that witness
Right.
back up,
I agree with you. It's trying to figure out what you've done wrong, and you're going to have 12 new people. And as Billy said earlier, we don't get to sit down and talk with folks and really hone in on who our juries are going to be. It's kind of potluck. So it's a new trial, the same stuff, but 12 new people. We don't know where that's going to go. Like you say, it's hard to get 12 people to agree on anything.
Yeah, get your daughters to agree on dinner, right?
Right. Where are we going to go?
Yeah.
We talked about video surveillance a second ago. Are juries expecting, all of the DNA and blood and video surveillance, the so-called CSI effect?
I think so. I like to start off my cases by telling them this is not a Netflix documentary. This is not a crime novel. I like trials where the crime happened on video, right? That sure makes it a lot easier for me, and when we have our share of those. But I think it is important to give some realistic expectations. Watching a show like that the other day when, they put it in their phone and there's your thumbprint and every place he's ever lived and where he moved here from, that's just not reality.
What has happened, and we're seeing it more and more, is the advent of the Ring doorbell camera.
Yeah.
I'm involved in a case right now where somebody said a certain person did a crime at a house, and the law enforcement went and checked on everybody's Ring doorbell cameras, and you can see the vehicle driving down the road. So the advent of Ring doorbell cameras has greatly enhanced law enforcement. It's given us more evidence because we can go out from the defense side and say, hey, did you check the Ring doorbell cameras? Yes. Did you see my client's car or him walking down the road? No, we did not. So it works both ways. But I mean, you're seeing it, almost every business has some kind of video surveillance.
Right.
City of Myrtle Beach
inside or
has
outside.
thousands of cameras throughout the city of Myrtle Beach as well.
And the city of Myrtle Beach has them on poles when they're working.
Yeah.
That can track vehicles.
A lot of people complain about the fact that Big Brother is watching because of all the license plate readers and all the real-time crime centers and things like that. I mean, is that, as far as constitutionality, is that something the defense ever brought up as far as whether or not?
What's that Tom Cruise movie?
Minority Report.
Maybe it gets to that same exact point.
But it's all in public. It's no different than you sitting out there with a video camera,
Yeah.
videoing.
Yeah, there's allegations that people say we don't want to commit our crimes in the city. We got to do it out in the county because everything's on video in Myrtle Beach. Whether it's true or not, I don't know, but I've heard that here. So,
Tell you what, we're going to run to another break here real quick. When we get back, we'll have just under 10 minutes. So if you've been waiting to give us a call, don't wait any longer. Call us right now. Phone number's on your screen, 848-8080. Of course, 843 area code. Call us today and we'll get you on the air right when we get back. Criminal law, that's our topic here today on Legal Access, brought to you by the McGuire Law Firm. Our topic today is criminal law. If you have any questions about anything specific like traffic tickets, drug arrest, DUI arrest, things like that, or maybe the court system or our criminal justice system in general, give us a call here today. We'll be happy to answer them, but call us very quickly because we're down to the last 5 or 6 minutes of the show on our panel to answer your questions. Want to thank once again Billy Monkton, also from the solicitor's office, Seth Oskin, and defense attorney Trent Chambers. They're all here for you, so give us a call and we'll get you on the air. All right. Let's go to something specific as far as DUIs are concerned. From a defense attorney standpoint, Trent, Billy, when you run into people on the street and or you're at a cocktail party and they ask you about DUIs or about drinking and driving, they say, hey, should I give a breath test? What's your answer to them as far as giving a breathalyzer sample?
I usually tell people if you hadn't been drinking or you maybe had one drink, blow.
I agree.
But if you've had more than 3 drinks, don't blow, because the way our statute is set up, 0.08 to 0.10 carries up to 30 days, 0.11 to 0.14, 60 days, 0.15 or higher, 90 days, in an interlock device. If you refuse the breathalyzer, you're going to be charged at the 0.08 to 0.10 level, which is the lowest. So my advice is don't blow if given the breathalyzer if you've been drinking.
Don't talk as well. Don't talk about your day. Don't tell them where you've been. Don't tell them what you had to drink. Just respectfully decline to answer those type of questions.
Same thing for the roadside sobriety tests.
You're completely within your rights to respectfully refuse to do those. 100% in your right.
Unless
now
it's a felony DUI.
Yeah, well, on the roadside,
Right.
you don't have to do those.
Yeah.
But in the situation, they are balancing tests, and as you know, most of our community is elderly, and I could give you the field sobriety test, and you could be stone cold sober, but maybe you got a bad knee, a bad hip, bad foot, and you are not going to look good.
People with a little, some age on them, they're not
Yeah.
going to do as well as young folks do on that.
Overweight people have a hard time with it.
Absolutely.
Seth, from a prosecution standpoint, how important is it to you to get a breathalyzer sample or the roadside sobriety test as far as DUIs go?
Yeah, I'm nowhere near the expert in DUIs that these guys are. It can only help because I want to look at BAC and have that number to show impairment. I typically get involved when it is a case where a search warrant was done or blood was drawn because somebody got hurt, or but I know on our magistrate level, we want to. That helps. It can only help, and the rest of the tests are very arbitrary.
Right.
But it depends on the case. I mean, if you can have somebody who didn't blow, didn't talk, and if they look absolutely terrible on that video, he's probably going to win that case.
Yeah.
You know?
The good thing about DUI cases is Trent and I are old enough to remember when there was no roadside video. It was the officer just testified as to what would occur. Videos are great. They work both ways. They can help you as a defendant, but they can also extremely hurt you. And a lot of times once your client sees the video, they decide what they want to do real quick.
Right.
Because if it's really bad, they don't want anybody to see it.
To echo what he's saying, and you probably know this from all the times you've been on here, the DUI statute in South Carolina sentences to paragraphs long. Murder, one sentence. So there's a lot to work with for both the defense and the state. I know we'd all agree best advice is to never drink and drive, but if you do,
Right.
yeah.
With the advent
have
of
some
Uber and
consequences.
Lyft, I'm surprised. I think our caseload has actually gone up on DUIs, believe it or not, even with Uber and Lyft.
I agree. I don't think that it's affected it really at all.
Not slowed it
Still,
down.
People come to the beach and it's 24/7 party.
Oh yeah, pretty much. That's what we're here for. All right. We usually get a lot of questions during criminal law about expunging a record if somebody's got an old-time conviction on something. What kind of process do you have to go through to be able to expunge a record, or can you?
If it's a felony, you're not going to get it done. If it's a misdemeanor in lower court, if you don't have any other charges, after 3 years you can get that expunged. And when people call my office, we generally refer them to the solicitor's office to have it done. We don't charge somebody to have that done because there's an administrative fee through the solicitor's office. You fill out a form and you can get it expunged yourself.
But it has to be a charge. We can only help with a charge in South Carolina. We have so many people move down here. They call us wanting an expungement, but it's a charge in New York, New Jersey. I'm like, we can't help you. You're going to have to go up there and hire a lawyer up there to try and figure out if that's expungible up there. But Trent's right. If it's a felony, the only way to get it off your record is a pardon.
Right. Tell you what, we're just about out of time here, but I want to thank everybody for being with us here today. Defense Attorney Billy Monkton, also from the Solicitor's Office, Seth Hoskin, and Defense Attorney Trent Chambers as well. I'm Dave Priest. Next week when we get back together, we'll have a different topic for you. I think bankruptcies are going to be our topic next week. So if you have any questions about that, hold on to them, or you can email us in advance. Our email address is legalaccess@wmbfnews.com. If you didn't get on here today, but you had a question about criminal law that you didn't want to talk about in public, you can use that same email address and we'll answer you off the air. legalaccess@wmbfnews.com. Again, next week, bankruptcy. That's our topic here next week on Legal Access. We'll talk to you then. I'm Dave Priest. We'll see you next Thursday right here on WMBF News.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal